I see that we are joined by our President and Dean, James McGrath, who would like to make some initial comments, perhaps.
I would. First of all, I'd like to thank everybody for coming here today. You're in for a real treat. I love listening to Professor Beery speak. He's really astute. He's always up on the topic. He's really prolific. He's written a number of great articles and just a fantastic teacher as well. So you're all in for a treat. And I'm just excited to be here today. I'm sorry for all the disruptions going on everywhere. It really shows that even though things are difficult right now, we can still do some really great quality programming, and we can all get together to discuss topics that are really important to all of us. So thank you very much for coming. And Paul, thanks for putting this together. And Terry, of course, for your mad administrative skills.
Thanks so much, President McGrath. Our special guest, as President McGrath indicated, is Professor Brendan Beery, who will have some initial comments for about 30 minutes and then we'll have a Q&A. We'll delve into a Q&A. We ask that you submit your questions in the chat on the screen that you see before you. You know, when we first scheduled this event, we thought we would be talking, for the most part, about the coronavirus pandemic, presidential powers, as it relates to constitutional law issues. And certainly we can take our conversation in that direction if that's what the audience would like to do. However, since scheduling this event, we've experienced the homicide of George Floyd in Minneapolis. Yesterday, we learned that the remaining 3 officers were charged with aiding and abetting. There have been peaceful protests in cities and towns here in the US and all over the world, as well as looting and property destruction in some places. We are so fortunate, Professor Beery, to have you here today as a constitutional law expert to help us sort through all of this to the extent that we can. Professor Beery has written extensively about constitutional law issues and has become a national media expert on the topic. You can read more about Professor Beery at the WMU-Cooley website. We will post his bio in the chat. Again, we encourage you to ask questions by posting them in the chat while Professor Beery gives his initial remarks, and then we can let the conversation continue. So let's get to it. Professor Beery, again, welcome, and thank you for taking the time to be with us today. And I guess the question is, where do we start? Probably a good launching point is to talk about the Constitution generally, its structure, its endurance, its power, and then get into some of what is happening today. So if you'd like to take it away, I'd like to introduce everybody to Professor Brendan Beery.
Thank you so much to both of those introductions. It's very kind. I'm going to try to, can everybody hear me? Yeah, okay, good. I'm going to try to go ahead and share my screen here because I want to accompany my comments with a PowerPoint presentation, so bear with me while I do that. Always takes a second. Okay. I was debating when I put some materials together for the presentation whether this slide would scare people off, and I'm hoping it doesn't. There is just no way around the times that we live in. Being, I've been teaching constitutional law for a long time. I've been around the block a few times, and I don't ever remember a time like this in my lifetime. And I think it's safe to say in most of our lifetimes, this is a unique time. As Dean Zielinski mentioned, not only do we have the COVID-19 pandemic to deal with, but in the last week or to 10 days, we now have coming back to the fore, the problem of institutionalized racism. We have the economic pressure that everybody is feeling with unemployment, and obviously we have some unrest as a result of the George Floyd homicide. Incidentally, I don't have this as part of my prepared remarks, but if anybody has comments about first, second, or third degree murder in Minnesota, I've done some research on that as well. So if people want to ask about the charges. Now, from a constitutional standpoint, I want to try to strike an optimistic tone through this, and 2 points to emphasize. Number one, and I said this to my class the other day, as much as everybody's hurting and everybody is in pain and everybody's worried, I do hope that people who are law students or people who are considering becoming law students that once in a while you look at the world around us and say, that's why I wanted to be a lawyer. I know that as I watch many of the events that are unfolding, I feel that way myself, that these are the reasons why I wanted to be a lawyer to begin with. As optimistic as I am about our future, injustice is never going, it's not in my lifetime and probably not in yours, is never going to go away. So we're going to need lawyers to sort through these issues and to be the grown is the way I often put it. Now, so number one, this is a good time to want to be a lawyer. And number two, it is an absolutely crucial time for people to develop a rudimentary fundamental understanding of the Constitution. So I want to talk, as Dean Zielinski mentioned here, about some basics first. Okay, optimism versus pessimism. I think that that the Constitution will endure. I'm seeing comments in the media from people who are beginning to question that. I don't know if everybody's. I woke up this morning to a comment from a retired Marine general who said in Foreign Policy magazine, I believe, to mark your calendars for June 1st, 2020. Warning that that was the possible beginning of the end, as he put it, of the American experiment. So there's some pessimism out there. It's our job, of course, as legal professionals and would-be lawyers to make sure that that doesn't happen. But that comment and other comments I've heard bring to mind the whole idea of what it takes for a Constitution to endure, to make it through rough times. And there are 4 principles that I want to very quickly run through. Number one, the framers, the founders of the Constitution were convinced that it would only work if the public was an informed public. And what I put up here is a quote from Thomas Jefferson, who said that an informed people can be trusted to govern themselves because they can correct the government when things go wrong. Obviously, the flip side of that coin is that a public that is not informed is in trouble. Maintaining a constitutional republic, it's absolutely crucial to that, that we have an informed public. So that's one of the things that's critical. And again, that we seek to help promote here is making sure that we do our part to educate people on the Constitution and to the extent that we can on other matters as well, like our history. The second component to successful constitutional endurance. I have a friend who says this all the time and reminds me of this all the time because we talk about the structure that the Constitution put together. And sometimes I have to be reminded too. The institutions that we have, that the founders gave us, are only as good as the people who populate them. We rely entirely on the good faith of public officials who occupy those institutions to maintain those institutions. By the way, this quote is from Alexander Hamilton. So I'm quoting some heavy hitters here, right? To watch out for people who would, as he put it, throw things into confusion and ride the storm so that he may ride the storm and direct the wind. That's an interesting quote there. Next. This is an odd term that you won't see many people throwing this around unless they've done some studying of the Constitution. The framers, George Washington in particular, but the framers in general were very suspicious of political parties. They did not want a republic built on tension between or among competing political parties with competing ideologies. What they wanted, they did want tension though. They didn't want tension between or among political parties. What they wanted was tension among the 3 branches of the federal government, primarily. They referred to this as institutional jealousy. The idea here that for our government to function in a healthy way, and again, for our Constitution to endure, each one of the 3 branches has to do what it's supposed to do and has to stay in its own lane, so not do what it's not supposed to do. You've heard checks and balances, just about everybody's heard that before. We are supposed to live in a country where The president jealously guards, that's why we call it institutional jealousy, right? Jealously guards the president's power. Congress jealously guards legislative power, its power, and the Supreme Court jealously guards its power. Now, when you have a system where, and I'm going to stay as apolitical about this as possible, and I won't mention any particular political party, but when you have a system where one party controls multiple components of the federal government, and instead of the institutions, for example, Congress and the president, instead of them going at it, they're always colluding, right? They're always on the same page. We lose that institutional tension and those checks and balances that are supposed to safeguard the republic. So that's a third component. We got an informed public, you get the good faith of officials who occupy our institutions, and institutional jealousy are three of the four components of a healthy constitution that I'll talk about. The final one is, now it sounds like I'm talking about metallurgy, I'm not, is malleability and ductility. And I guess you could sort of, you could subsume both of those terms with the word flexibility. I recently read a book, really interesting book, called of all things, Constitutional Endurance. I don't know if you can see that, but where there's now scholarship that has studied constitution, not just the United States Constitution, but constitutions around the world, and which ones survived and which ones didn't. And the authors who wrote this book said that there are two possible ways for a constitution to endure, but you need one of these two for a constitution to endure, because a constitution, look, to last centuries, right, generation after generation, a constitution must adapt to changing times and circumstances. Malleability, of course, is the property of bending without breaking under certain stresses. Ductility means not only will, if we're talking about the Constitution here, not only will it not break under new circumstances like a pandemic, right, or like institutional racism, that it won't break under the pressure of events and circumstances. Ductility is the property of stretching into time, or in metallurgy, you can think of stretching a rubber band. How far can you stretch it, right? So it's not, the pressure is not going down, the pressure is coming out like this. How far can you stretch it before it snaps? So the Constitution has to have both of these properties. It has to be able to bend to new circumstances, and it has to stretch into time. Now, these two authors said that for that to happen, one of two things has to be present in the Constitution. Either it has to have flexible, general, vague terms built into it, or it has to be easy to amend. Because one way or another, either courts have to be able to interpret the Constitution in new ways as time evolves, or the Constitution has to be easy to amend so that it can be adapted to new times that way. I can tell you this, the US Constitution is not easy to amend. It's not easy at all to amend it. So their theory, and it's a pretty solid one, is that the reason the US Constitution has endured is that although some of it is written in very specific terms, right? You have to be at least 35 to be the president. Members of the House serve 2 years. There's nothing vague or general about that. But their use, the constitutional drafters, their use of terms like due process, liberty, very general terms, privileges and immunities, interstate commerce, right? These are general terms that can be interpreted to adapt to new circumstances. These are the key components to constitutional health or constitutional endurance. And so I hope that you'll think about this as we navigate through the times we live in, whether any or all of these are eroding and need repair. So that's a very general overview of constitutional health. Now, in terms of what people are asking about now, the questions that are everywhere sort of divide into two categories. One deals with constitutional structure, and Dean Zielinski mentioned this. What's the president supposed to be doing? What's Congress supposed to be doing? What are courts supposed to be doing? And what are states supposed to be doing? You must have noticed by now that there's a huge debate about who does what. So one of the things we study in constitutional law is the structure of government, its power, the scope of its power, and some limits on that, structural limits on that. Incidentally, if you show up we're happy enough to have you as a student, you'll see that this is actually how con law is divided up. On the left side of your screen is con law 1. That's the structure of the Constitution and the institutions it sets up. On the right side of your screen, another different set of questions is not about the power of governments and the structure of government and who's supposed to be doing what, but rather what rights do I have when the government's coming after me for some reason. So those are two very different types of questions. And I want to go through those one at a time briefly and hit some of the high points of the current debate, what's going on in our country. Number one, when it comes to structure, constitutional structure, there are two layers of government in our system. One is the federal government and the other is states, like the state of Florida, the state of Michigan, and subdivisions of states as well, like cities and counties. Those count as state. The federal national government has certain, what lawyers call, because we like to use fancy language, enumerated powers. There's a list of things that the federal government is allowed to do in the Constitution. And if it's not on the list, it's not on the list. One of those things that the federal government is allowed to do is regulate, I mentioned this earlier, interstate commerce, which is quite a broad power, but and it's probably the broadest power that the federal government has, is the power to regulate interstate commerce. It has power to do other things too, coin money, borrow on the credit of the United States, the tax, all that stuff, raise armies and navies, that belongs to the federal government. The states have what's called the police power, and this is critical. The police power is the general authority. It's not enumerated powers, right? There's not a bullet point list of things states can do. States just have the general authority to regulate for the health, safety, and general welfare of the population. So again, trying not to get too into the politics of it, there has been a debate. President Trump at one point said that it was his job to decide about quarantines, to stay-at-home orders and all that kind of stuff. And he's repeatedly said that the governors are doing what I've authorized them to do, or I can stop them from doing what I don't want them to do. That raises the issue of this tension here, right? I mean, is it the federal government that is supposed to be in charge of these health measures and things of that nature, or is it the federal government, or is it a state? Generally speaking, our understanding throughout history has been that it is at the state level that the government has that police power for health, safety, and general welfare. Now, another issue has come up as well, and that's law enforcement, and particularly in light of the protests, where again, and I think this is where some of the military brass has decided that they're going to start to step in here and make their feelings known. The threat to use U.S. military forces to enforce the law within certain states, whether governors want U.S. military troops there or not. That is raising another huge question of federal versus state, who is supposed to be doing what. Here I have to stop and say that this is an interesting point about American constitutional history. It's fair to say that we have a formal constitution, the one that's written down, and we also have sort of an informal constitution, which is a set of norms and protocols and traditions that have evolved over time, even if they're not written down in the Constitution. And one of those is that we don't use U.S. military force against civilian population within the United States. That is not actually specified in the Constitution, but it's been part of our tradition that we don't do that. That law enforcement is up to states, except for federal agents who are enforcing federal laws. General law enforcement is up to states, and that includes things like crowd control and all of that. So that tension has emerged. This tension has also emerged. Now, we're talking federal and state. At the federal level, there are 3 branches of government, and each one of them is supposed to stay in its lane. There seems to be widespread misunderstanding these days about which branch is supposed to be doing what. The executive branch, as the word suggests, executive is there to execute, right? To execute what? To execute the law. And who is supposed to make the law at the federal level? Well, that would be Congress, the legislative branch. So there's actually a link between the authority of the president and the authority of Congress. This is why courts typically hold that the president is not allowed to do anything that he's not authorized to do, either directly under the Constitution, like be the commander in chief, the Constitution says that, or by an act of Congress. This is going to be, if the president were to follow through on the suggestion that military troops would be deployed in the United States under something called the Insurrection Act, the issue would become whether that act actually authorizes the president to do that. And right now, most of the lawyers who are following this, and I'll have to include myself among those, think that a federal judge is probably not going to have much trouble saying that what is going on in the United States is not an insurrection. An insurrection is an attempt to overthrow the government. And while the government may feel threatened by certain certain movements or certain activists, there certainly is no attempt to overthrow the government. So it looks like that threat would be in legal jeopardy, let's say that. So we have questions about which level is supposed to be doing what. It looks like we're living in circumstances where the wrong level of government is trying to do certain things. And not only that, but we're also living in times where there's a tremendous amount of questions about which branch is supposed to be doing what, and tension on that level as well. I want to talk for a minute about rights as well. So there's a little bit of a discussion of structurally how the Constitution works and how it endures. The rights that have come into play most recently, and that's a photograph right there of Lafayette Square. That is one of the most famous First Amendment locations in the United States. And the reason is that I'm sure many of you have been to Washington, D.C. and visited and seen the White House. Not to get too in the weeds here, but this is Lafayette Park on the north side of the White House. And Pennsylvania Avenue is well beyond what you can see here. Though you can see people in the foreground there who are standing on Pennsylvania Avenue. If you've been to DC and seen the White House, I don't know about you, but I was shocked how close you can get to the White House. You feel like you could throw a stone at it. From the north side of the White House, this side, you feel like you could throw a stone at it and hit it. On the south side of the White House, I don't have a picture of that. If you're on the other side of the White House, the roadway where you're standing is very far away from the White House. There's a big lawn, and it's hard to see. So this territory, right, on the north side of the White House, right, this is, people want to have their protest here, because if you have your protest here and you're loud enough, the people in that building can hear you. This is where it happened, right? This is where it happened the other night, where it appears that the Attorney General ordered forces. We're still not clear on what federal agencies were involved. It was probably multiple federal agencies, but ordered the dispersing of the crowd in Lafayette Square so that the president could go to St. John's Church to take the photographs with the Bible. That is one of the things that has generals very upset. And some of them are saying it was a First Amendment violation. So I want to talk about that for a minute. One of the keys, no matter what constitutional right you're talking about, this is one of the things that's really been difficult to get a lot of activists on either side of certain issues to understand. The courts constantly say things like this: the Constitution is not a suicide pact. And so we don't interpret constitutional rights as being absolutes. So, for example, under the First Amendment, you do not have a right to shout fire in a crowded theater. That's the famous example. We have conspiracy laws that make it illegal to communicate in certain ways. It's illegal to threaten the life of the president of the United States, even though you have a right to free speech. So they're not absolutes. When it comes to how the government deals with demonstrations, I want to talk again briefly about two different types of cases where courts say it's okay for the government to regulate speech. Again, especially when we're talking about some kind of a crowd control or a demonstration. There are certain things that the government can do to regulate speech. But we've got to talk about under what circumstances. One is that the government can punish conduct that's expressive if the conduct part of the expression is harmful. So, for example, if you're burning a copy of the Constitution on a sidewalk somewhere, and you hold it out and set somebody's hair on fire, and you're arrested for that, the government can arrest you not for burning a copy of the Constitution, but for setting somebody's hair on fire, right? For doing so in a way that's dangerous and in public. So there are times when people express themselves through conduct, burning things is the most common, but there are other ways too. But when people are expressing themselves through some kind of conduct, there are circumstances under which the conduct can be targeted as long as the speech is not being targeted. I'll circle back around to that in a minute. But that's one thing, is harmful conduct regulations. The other one is called a time, place, manner regulation that the Supreme Court has said as long as it's reasonable, it's okay. Even if, I won't tell you who my favorite politician is, right? Because it doesn't matter. Even if somebody was outside my house screaming and yelling in support of my favorite politician, if they were doing that at 3 o'clock in the morning with a bullhorn on the sidewalk in front of my house, I'm calling the police. And obviously that has nothing to do with me disagreeing with the message, because I may agree with the message. The point is that's not the time or the place or the way, the time, place, or manner for the speech. So courts basically say it's okay for the government to mess around a little bit with speech, move it around, right? Regulate it in ways that it's appropriate timing and the appropriate place and the appropriate manner of speaking. Now here is the interesting part. Under either a conduct regulation or a time, place, manner regulation, so you're punishing somebody because they undertook conduct that hurt somebody, or you're just moving things around a little bit and tinkering around a little bit. Either way, the restriction must be, in order to be constitutional, the restriction must be content neutral. Content neutral, which means unconcerned with the subject matter of the speech. The minute a court sniffs out, right, that you did something to disperse a crowd, okay, you're all hearing what I'm saying, right? To target a particular individual, during a demonstration, anytime a federal judge sniffs out that was done because of the message being conveyed, or even worse, the viewpoint being conveyed. Let me explain the difference between that content and viewpoint for a second. A content-based restriction would go like this: no demonstrating about the war. About the war. That's a content-based restriction because it's about the subject matter of the speech, whatever war, the war. A viewpoint-based restriction would go like this: no demonstrating against the war, right? You can demonstrate for it, but not against it. Courts are on the lookout for content-based restrictions, and that viewpoint-based restrictions are almost per se automatically unconstitutional. But to be reasonable, a time, place, manner restriction or a conduct restriction has to be content neutral. The government is not allowed to be targeting demonstrations or speakers because of the message being conveyed or the subject matter being discussed. So that would be one thing that's going to be a problem here. Now, speaking specifically of the Lafayette Square incident from a couple of nights ago, the second requirement under either a conduct restriction or a time, place, manner restriction is that the government has to have a significant, important, substantial interest. And I think this is where, when I say generals, I'm talking about General Mattis and another general named General Allen. Mattis, of course, being the former Secretary of Defense. General Allen was the commander in theater, I believe, in Afghanistan during our war, or during a portion of the war against ISIS. So these are heavy hitters in contemporary military circles. I think that the reason those two are starting to speak up and that they're very upset about what happened on Lafayette Square was the contention, and we'll see how this all pans out, but the contention that the crowd was dispersed merely so the president could have a photo opportunity. And so let me repeat, any kind of messing around with a crowd like that by the government, it has to be content neutral, not based on what the people are protesting about. And it also has to be for a significant interest. It can't be for some kind of minor, right, unimportant interest. So those are some principles to keep in mind under the First Amendment. I'm going to say one more thing about the First Amendment before we move on. The Twitter thing, okay, sometimes you have to laugh. The new war between the president and Twitter. Another thing to keep in mind, and another thing the whole population needs to get to understand. Twitter is a private platform. It's a private company. It's massive, but it's private. It's privately owned. The Constitution, you can think of the Constitution as a big speed limit, a big flashing speed limit sign. Now, you and I know when we're on the highway that the speed limit is meant for us because it's on the side of the road, right? I see it on the side of the road I'm on, and it's facing me. So I know that that speed limit, it applies to me. The Constitution is a big flashing speed limit, but it is not facing citizens or persons under the jurisdiction of the government. It is facing the government. The Constitution is a speed limit, right? A set of limits that is facing the government. In other words, the government is the party that is restrained by the Constitution. Whether it's the federal government or state government, that's who is restrained by the Constitution. I am not, as a private person, I am not capable of violating somebody's First Amendment rights. It is under the Constitution, it's impossible. Why? Because I'm not the government. I'm a private party. So you need to apply that principle to Twitter. As between the president and Twitter, Twitter is a private company. The president is the government. That means that Twitter is not capable of violating, because I'm hearing that. Twitter violated the president's First Amendment rights. Twitter cannot violate anybody's First Amendment rights. Twitter is the one that has First Amendment rights because it's a private actor. Twitter has a First Amendment right to decide what's on its platform. I hope this all makes sense, right? As a private entity, Twitter cannot violate anybody's constitutional rights. The president, on the other hand, obviously can violate people's constitutional rights. So the First Amendment issue here in that little back and forth is not whether Twitter has violated the president's First Amendment rights. It's whether in signing an executive order that appears to be in retaliation for Twitter. I shouldn't have assumed that everybody knows what we're talking about. Twitter tagged a couple of the president's posts with fact checks. And the president after that signed an executive order about social media companies. We're still trying to sort out exactly what happens there. The president claimed that Twitter violated his First Amendment rights. Now Twitter is claiming that the president violated its First Amendment rights. And so people just need to be aware, again, of this principle. Only state actors, governmental actors can violate constitutional rights. So Twitter is incapable of doing that. That's not to say that Twitter should be. I'm not taking a policy stance on this at all. I'm not saying Twitter should be monitoring anybody's speech or shutting down anybody's speech. I'm just saying that Twitter, if it shuts down somebody's speech, it's not violating the First Amendment. It might be violating some other principle, but it's not the First Amendment of the Constitution. Okay, so that's the First Amendment. Other issues that are coming up are due process. This has, well, it has to do with all of the current events that we're facing, but it has especially to do with the COVID-19 stuff. A lot of people have been talking about the right to a speedy trial and things like that that have been put off because of social distancing and courtrooms are not open for jury selection and jury trials. So that's another issue that courts are grappling with. And then finally, the Constitution, there are rights that are listed in the Constitution, and that's mostly in the Bill of Rights, which is the first 10 amendments to the Constitution. There are also rights that courts recognize that are not actually listed in the Constitution. And that's another thing that people really, they shake their heads, like, how can If the Constitution doesn't say anything about who can marry whom, then why is it a constitutional issue? Well, the reason is two of the amendments. The Ninth Amendment says that the listing of certain rights in the Constitution will never be construed as denying the existence of other rights. And if we were to get into what the Ninth Amendment means and where it comes from, I could go on for another 90 minutes, so I won't. But bottom line, the Ninth Amendment explicitly says that just because there's a list of rights in the Constitution doesn't mean that there aren't other constitutionally protected rights. Furthermore, the 10th Amendment, which is often miscited and misquoted, says that there are three spheres of jurisdiction in American governance. The 10th Amendment says that the power that is not given to the federal government, the national government under our Constitution, is reserved to the states or, listen to this part, or to the people. And or is disjunctive. It means not both. So there's power that goes to the federal government, there's power that goes to the states, and there's power that belongs only to individual people. That is why courts recognize, quote unquote, unenumerated rights. Certain rights that, even though they're not listed in the Constitution, are so fundamental to life in a free society that if these rights could be interfered with by the government, then we have to stop saying that we live in a free country. So the Supreme Court, for example, has said that marriage is a fundamental liberty interest protected under the Constitution, even though the Constitution doesn't mention it. The Supreme Court has said your right to raise your kids without the state's interference, assuming you're a competent parent, is a fundamental right. Your right to family living arrangements to decide what relatives you're going to live with is a fundamental right. Lots of these rights have to do with privacy types of interests. These are coming into play as well. People are asking, do I have a constitutional right to go back to work if I want to? Do I have a constitutional right to leave my house? Do I have a constitutional right to go shop? I mean, to do all these things. The bottom line on this, and then I see where I'm pretty good on timing here, then I'll stop and open it up. The bottom line on this is that even if a right is fundamental, to repeat what I said earlier, no right, whether it's listed in the Constitution or recognized by courts, even if it's not listed in the Constitution, no right is an absolute. Courts generally let the government mess around with people's rights. That's not a term of art, by the way, mess around with. But courts generally will let the government mess around with people's rights if the government can pass a test called strict scrutiny. And strict scrutiny goes like this. If the government has a compelling reason to do what it's doing, and the most compelling reason you can think of is, of course, saving people's lives, and there is no better way to do it, that's called strict scrutiny. So if a judge finds, for example, a stay-at-home order or a social distancing order, if the government's interest is compelling, to save people's lives, and you've got a bunch of scientists and medical professionals telling you that the only way to do it is to keep people 6 feet apart under the types of orders that we've seen. Again, we live in interesting times. I've been telling students, we live in one of the few circumstances where the government, even if it is interfering with people's fundamental rights, when it comes to the COVID-19 side of what's going on here, may pass strict scrutiny. Right? These are exactly the kind of circumstances you look for when you're looking for a set of facts where the government might actually satisfy strict scrutiny by proving that what it's doing is the only way to achieve a compelling interest. So there are no absolutes, and under certain circumstances, the government can act even if there are serious constitutional rights at stake. Okay, so I think that looks about right. I think I went about 30 minutes, so this would be the time, I think, to open it up.
Thanks so much, Professor Beery. Does anybody have any questions out of the gate for the professor? You know, I was, when you were talking about the constitutional endurance, I was, what immediately came to mind when you talked about informed public is a partisan media. Right. Which has changed so dramatically in our lifetimes. You know, you don't have 3 channels anymore. You've got, multiple sources that you could access. And seemingly the same event can be described in a variety of different ways. How do you preserve the Constitution in an environment like that?
That's the challenge, and it seems like a lot of it is going to come down to people getting outside their comfort zone. Yeah, we all know the outlets that we're talking about, and most of us spend our time watching either mainstream media outlets or on social media outlets that reinforce what we already believe, and we tend to reject anything contrary to what we believe. But I think you've hit on something here. Again, I can only speak from my own observations and my own experience. I don't ever remember a time when, Senator Moynihan famously said, "You're entitled to your own opinion, but not your own facts."
Right.
And we live in a time where people seem to think they're entitled to their own facts, and that's something that we work with law students as well. When law students get to law school, because we all everybody comes at life, through all of our experiences, with our own past and our own inclinations and our own biases. That's human nature. One of the challenges of law school, but I think it's one of the beautiful parts of law school, is it challenges you to develop a new way of thinking, and to check your own opinions, and especially to know the difference between an opinion or a fact. So as an example, to say that I'm wearing a blue button-down shirt right now would be a fact. It's an observable, empirical fact. You can see it, you can check it out. If you were to say that's an ugly shirt, that's not a fact. And if you did a poll of Americans Professor Beery just said he has an ugly shirt. That's a fact, right? There's going to be a lot of people who say, "Oh yeah, that's a fact. That's an ugly shirt." And then you get to law school and you realize there's nothing factual about that at all. That is a characterization or an opinion, and it's not a fact. So lawyers we equip ourselves to evaluate evidence, and to do so under accepted principles that we call rules, and to reason our way through problems that way. Once you get outside of this realm, that's why I always tell students this too. Being a lawyer kind of drives you crazy, because everything seems different after you go to law school. I can't even read a no parking sign without taking issue with it, right? The way it's drafted. So it changes your way of thinking, but it becomes very difficult to watch media platforms where non-factual information or counterfactual information is constantly streaming as fact. I don't know the solution to that. I guess that's a little above my pay grade, but that's the problem. And it's a problem that we need to recognize, because that is one of the pillars, as you said, of constitutional endurance and survival. We cannot be running around disagreeing on what is actually happening when it is happening.
Right. Again, if you have questions, go ahead and put them in the chat, or jump in between me and Professor Beery. I wanted to talk about the idea of institutional jealousy and the necessary tension between the 3 branches of government. How does one, given that's contemplated or indicated in the Constitution, I think a lot of us may be looking at our government and feeling a strong sense of inactivity and stalemate. Mm-hmm. And so how can the Constitution guide us to try to get a government that moves, if you will?
Yeah. This again comes down to the will of the people. When we as people are as divided as we are, we produce a government that is as divided as we are, because we elect representatives who tend to take extreme positions on and does is create it's a really interesting way you phrase the question, because this can cut 2 ways. either when one party is in control of everything, right, there's just a rubber stamp and there is no check on anything. Or if you have opposite parties in control, so for example, now, if you look at the dynamic, the House of Representatives, it's very difficult for the president to get anything through the House of Representatives, any proposals through the House of Representatives. It's very easy for him to get anything he wants through the Senate, or vice versa, the Senate to get anything it wants from him. And this is all a result of partisanship run amok. Certainly in our founding era, parties started to develop, the Federalist Party, the Anti-Federalists and all that. It started to develop, but there was some trust that would never overtake institutional tension in a way that it has. And so right now, you either have obstructionism or you have no checks and balances at all. And again, for a healthy constitutional republic, and that comes down to us. People have got to start paying attention. If I hear one more person say elections don't matter, I'm going to lose my mind.
Yeah, and I'm assuming that there's got to be a heavy lean on the good faith doctrine too. That our leaders act in good faith. That may not mean in a partisan way, right?
Right. That's right, and that's a great point. There is a link. I mean, to operate in good faith as a member of Congress is to protect your institution, Congress.
Yeah.
The same thing goes for the court. Now, the Supreme Court is an interesting case in point. The Supreme Court is probably the only one of the three branches that is constantly mindful that it needs to maintain its at least appearances of integrity, and to maintain its institutional power. Because, and this is an interesting dynamic. The Supreme Court has nothing. The Supreme Court relies for its authority and its power largely on the acquiescence of the other two branches, because the Supreme Court does not have an army. The president has an army, right? Congress is the one that raises armies. The president's the one that commands the army. All the Supreme Court has is the ink that it writes with. And if the other two branches decided, actually, President Andrew Jackson once said, and he's the only president who said this yet, although I know another president who's gotten close, but Andrew Jackson said, when the Supreme Court ruled against him in one case, he said, well, that's their opinion, let them enforce it, okay? Recognizing that the Supreme Court cannot enforce its own opinions. That's up to the other branches to do that. So it's more common for a Supreme Court justice to be what we call an institutionalist. And I think John Roberts, the Chief Justice, is an institutionalist, which is why I think there's a lot of, now that there's been a switch on the court from Justice Kennedy to Justice Kavanaugh, there have been a lot of questions. Will the court overrule Roe versus Wade? Even though Justice Roberts thinks that Roe versus Wade was wrongly decided, I don't think that he'll vote to overrule it because of the institutional, right, the institutional obligation he feels not to preside over a court that's swinging wildly all over the ideological spectrum. So the Supreme Court tends to have that instinct of institutional pride, jealousy, protection, whatever we want to call it. The other two branches seem to have lost their way.
Yeah, we're going to get to Tyler's question in a second. Just you brought up the Supreme Court. Do you have any sense of what the founders were thinking of having an odd number of Supreme Court justices as opposed to an even number, where there could be kind of a part, if they're in a two-party system, there could be a more even perspective, and that tension would actually occur there as well?
Yeah. There actually is no constitutional rule about how many justices there have to be. That's up to Congress. And but that's another great question. I think that's another thing that I think we're so enculturated that we have 9 justices that people think that the Constitution requires 9 justices. Okay. We've actually had other numbers of justices in the past. The Congress is the one that's decided we need an odd number because they don't want ties. Because when the Supreme Court ties, and that can still happen because sometimes one justice will take himself or herself out of the case, and then you have a 4-4 split. All that does is leave lower court rulings in place. It doesn't resolve anything.
Gotcha.
Yeah.
So Tyler's asking if you could, in fact, talk about the charges brought against the officers yesterday and kind of your thoughts and how it relates to the Constitution.
So I can talk about the charges. That's not too much of a constitutional issue as a criminal law issue, but it's very interesting. I've taught criminal law before, and the degrees of murder can take a while to get a hang of what's going on. Minnesota is very typical of other states, sort of the majority approach to how to handle homicide statutes. And I'm not saying that it's the best way to handle homicide statutes, it's probably not, but it's the majority way. And that is to say, there are three types of murder. Homicide is the killing of a human being. So there's obviously no question that the two coroners here said it was a homicide. Because a human being caused the death of another human being. The worst kind of homicide is murder. There are degrees of murder, but murder in general is the worst kind of homicide. There are other types of homicide: manslaughter, negligent homicide, vehicular homicide, things like that. Murder is the top. And there are three kinds of murder. Two of the types of murder involve what we call specific intent. And specific intent works like this. If I shoot somebody, then there's if I do that intentionally, then there's no question I intentionally shot somebody. But when I shoot somebody, I don't ever shoot anybody. But if I were to shoot anybody, I could either do that without intending to kill the person or with the intent to kill the person. If a prosecutor can show that I intentionally shot somebody, but the prosecutor can't show that I intended that person die, then I did not have specific intent, because specific intent means not only to intend the act, but to intend a specific consequence. So specific intent murder is not just that I intended to shoot you, but I intended that the result be that you die. That's specific intent. In Minnesota, first and second degree murder are both specific intent murder, meaning that to prove that, the prosecutor in Minnesota is going to have to show, to prove either first or second degree, would have to show that the officer, or the former officer now obviously, intended to kill George Floyd. Now, what separates first from second degree is that first degree murder includes something beyond specific intent. Not only would a prosecutor have to show specific intent, the prosecutor would also have to show premeditation, which means a plan in advance, right, to do it. Basically would have to show that when the officer showed up at the scene that he intended to kill George Floyd. So these are, now I'm not opining on whether the prosecutor could show that or couldn't show that, but obviously first degree murder would be harder to show than second degree murder. One of the reasons it looks like we got bumped up to second degree murder was because there's emerging evidence that the officer kept his knee on George Floyd's neck long after Mr. Floyd became unresponsive. And even now, evidence emerging that another officer checked the pulse and found that there was no pulse. Those facts tend to lend themselves to actually a specific intent to cause death. Third degree murder is called depraved mind murder in Minnesota. Most jurisdictions it's called depraved heart, which is basically the type of murder where you create a known risk. You know that you might kill somebody. It's not that you specifically intended to kill them, but you knew that you might kill them. And depraved heart means you're the kind of person who doesn't care whether you kill somebody or not. Arguably, that's the most dangerous kind of killer, is an impulse killer, or somebody who just doesn't care. When I used to teach criminal law, and we talked about depraved heart murder, I said, think about the defendant this way. You'd be saying this is somebody who, if they didn't kill somebody today, they'll go to bed and have a peaceful sleep. And if they did kill somebody today, they'll go to bed and have a peaceful sleep. They just don't care. That is what the officer was originally charged with. And I think that would have been, that's an easy prosecution. Because there's no question he created a risk of death And there's no question from his response to it that he did not care whether he killed or not. But those are the three. Those are the three. Now there are other nuances thrown in there that I won't get into about when you can be moved from one charge to another. But that's the general way it works. First-degree murder is a specific intent plus premeditation, very hard to show. Second-degree murder is specific intent. You don't have to show premeditation. In other words, the intent to kill could have developed at any point before the death. And you can still be guilty of second-degree murder. Third-degree murder does not require specific intent at all. It just requires that you're the kind of person who doesn't care whether you killed people.
Gotcha. Professor Beery, can you unshare your screen so we can see your view of you? We know that you're a media hound, and people may recognize you already, but there you are. You know, you mentioned Twitter in the context of the First Amendment and its rights and thereof. So, if my memory serves correctly, Facebook is publicly traded now. Is that correct? I believe. Right. So, what would be the distinction between a publicly traded or public entity like Facebook and that of Twitter, a privately owned company?
From a constitutional standpoint, they'd both be the same, even if it's publicly traded, because there are a few cases, rare cases, where the Supreme Court will say a technically private a company is a state actor, but this court is not going to go there. So publicly traded doesn't mean publicly owned, and so it's still a private actor. And so Facebook, the reason Facebook is under fire, Facebook can do what it wants with that platform. Right? Again, they can't violate anybody's First Amendment rights. They've made a choice that they're not going to put a check on certain misinformation that is placed on Facebook, whereas Twitter is starting to move in that direction. And the reason people are attacking Mark Zuckerberg is because he can do that if he wants.
Gotcha. Any final questions? I don't see any. You know, Professor Beery, we thank you so much for this excellent and really timely conversation. We thank all of our participants, obviously, particularly those of you who are future lawyers, for attending today. And please join us next Thursday. We have another conversation next Thursday as we have a talk about civil rights. We'll have Professor Tracy Brain with us as it relates to our current climate. We're going to send you a short survey. Those of you who participated today, hopefully you'll take a few minutes to fill that out. And until our next time, please stay safe and take care of one another. Until next time, thank you.